Hello, everybody, and welcome to Law Bite number 280, dated June 21st, 2021. I'm Walter, your mobile historian and blue-collar scholar. Thank you so much for tuning in. This Law Bite is entitled Types of Appellate Court Opinions. Now, I myself, being the law nerd that I am, have been reading Supreme Court opinions for well over 20 years. And I can tell you that it is not something for the faint of heart. Supreme Court opinions often run hundreds of pages, okay? And it really helps to know what type of opinion you are reading when you read a Supreme Court opinion. You'll see terms within those opinions such as, unanimous opinion, majority opinion, concurring opinion, dissenting opinion, Procurium opinion, plurality opinion, in chambers opinion, slip opinion, concurrent/dissent. And you might be wondering, just what the hell do all those terms mean? For a rookie to reading appellate opinions, and these terms can be found throughout any type of appellate court opinion, not just the Supreme Court of the United States, and they can be found in some trial court opinions too, such as a 3-judge panel of the district court. But these terms all have specific meanings, okay? And those meanings, are essential for you to understand exactly what type of opinion that you're reading, all right? Now, like I said, I've been reading Supreme Court opinions for a long time. And I can tell you that as time goes on, they don't get any easier to read. Yes, you are able to decipher them and certainly filter out irrelevant details versus relevant ones. But what I'm referring to when I say they don't get easier to read over time is that these days, Supreme Court opinions tend to be more focused at getting the attention and the approbation of the legal community, rather than having the average individual understand what the court is saying. And if you ever read, let's say, a Supreme Court opinion from the 1950s or 60s versus 2020 or 21, you will certainly see a difference in the writing style and structure. Opinions back then use far more general language to express the same point, okay? And the average reader could understand the opinion just as well as a Supreme Court lawyer, all right? Whereas today, Supreme Court opinions are most definitely aimed at the legal community understanding them overwhelmingly versus the average individual. But that's neither here nor there, just a personal perspective. In any case, when you review appellate court opinions, all right, such as Supreme Court opinions, U.S. Supreme Court opinions, opinions from a state Supreme Court, or an opinion from one of the 13 U.S. Courts of Appeals, all right, you will see the terms that I mentioned earlier, okay? And of course, by appellate court, we mean a court that hears appeals from a trial court or from another appellate court. The Supreme Court of the United States, of course, sits at the top of the American judicial system, top of the federal judiciary, and it hears appeals from the 13 U.S. Courts of Appeals as well as state Supreme Courts. And it also hears appeals from 3-judge panels of the U.S. District Court, all right? Those are not that common, but cases decided in those 3-judge U.S. District Court panels, a trial court, of course, can automatically be appealed to the U.S. Supreme Court. So let's get into the types of opinions that you will see when you are doing your legal research and reviewing appellate court opinions, all right? The first type is a unanimous opinion, all right? Now, on an appellate court, you have more than one judge, all right? The logic, quite simply, is that 2 heads are better than 1, even though an appellate court usually always has a minimum of 5 judges. When you see an appellate court opinion that says unanimous, we are typically interpreting that to mean that each and every single judge on that appellate court has agreed to a singular position with respect to the disposition of an appeal, all right? All of the justices are on the exact same page, and they have all agreed to a signed opinion written by one of the court's members, okay? Now, unanimous, like I said, implies that all of them are on the same page. It ensures that all of them have agreed to a particular point. Now, sometimes, though, with unanimous opinions, it might draw a concurrence or two, okay? But for the sake of argument, we are deferring to the traditional unanimous opinion where all of the members of that appellate court are agreeing to the same point here in the disposition of that case in siding with either the petitioner or respondent. All of the justices agreeing to the same legal point, same opinion written by one of the justices or judges, okay? A great example of such a result was the landmark Brown versus Board of Education decision in 1954, authored by Chief Justice Earl Warren and joined by all the members of the Supreme Court. No concurrences, no dissents. The court is speaking with one voice, typically in a unanimous opinion, and it adds to the force behind an opinion when the court speaks with one voice, rather than speaking with 3 or 4, leading to potential confusion, okay? So that is a unanimous opinion. Typically the court, whatever court it may be, is speaking with one voice through one of its members, all right? Occasionally it might draw concurrences, but again, we're aiming at the unanimous decision when that court is speaking with one voice and through one voice, all of its members agreeing to a single legal position with respect to that disposition of the case. All right? So that takes us next to a majority opinion. Okay? A majority opinion, okay, is an opinion of the court, all right, where at least a bare majority of the court's members, all right, agree to a particular position in the law in the disposition of a case, all right, the disposition of an appeal, all right. That means if it was the Supreme Court, under normal circumstances, at least 5 justices have all agreed to a singular legal position in a particular case with respect to its disposition, all right? And that means, all right, 1 or more justices did not agree. The mere existence of a majority opinion implies that there are minority opinions, otherwise known as dissents, which we'll get to in a second. Now, with respect to majority opinions, again, taking the Supreme Court example, you will see a majority opinion in the form of an 8-1 decision, okay, a 7-2 decision, a 6-3 decision, or a 5-4 decision, all right? A 9-0 decision is what? Unanimous, exactly. So it's technically not a majority opinion because there is no minority position. All of them are on the same page, all right? So with the majority opinion, okay, like any other opinion of the court, it explains the court's decision and ruling in favor of either the petitioner or the respondent and the legal rationale for why it is ruling in favor of the petitioner or the respondent, okay? For those not familiar with that terminology, appellate terminology, the petitioner is the one who has sought review, the plaintiff, okay? Here in seeking review by the Supreme Court, all right? And the respondent is the one who has been appealed against, okay? The defendant, all right? In appellate terminology, we use petitioner and respondent as opposed to plaintiff and defendant, which is used in trial courts. All right. So that takes us to minority positions known as dissenting opinions. Now, dissenting opinions are written by one or more members, okay, of an appellate court or even a trial court, all right, depending on the circumstance, like those 3-judge U.S. District Court panels. But we'll focus, again, like it's the Supreme Court. Dissenting opinion is written by one or more members of that appellate court who entirely disagree with both the judgment and legal rationale used by the majority in that case, okay? Dissents almost always take issue with the majority's interpretation of the law and or its application of the law in the case at hand, all right? Dissents, ladies and gentlemen, can often get very personal, okay? In history, you have often had some fiery dissents, okay, in which, you know, the justice in the minority, justice or justices in the minority have, you know, practically indicted the majority for what they view to be a decision that's a step under horrible. Famous examples in history include Justice John Marshall Harlan II's dissents in the civil rights cases of 1883, as well as in Plessy versus Ferguson in 1896. In both of those cases, Justice John Marshall Harlan II blasted the majority opinions for their failure to uphold the 14th Amendment's commands at mandating equal protection of the laws to African Americans, okay? And, you know, Justice Harlan's dissents, of course, would be vindicated decades upon decades later in the Brown versus Board of Education case in 1954, all right? So dissents do not carry the force of law. However, what they do provide is powerful cannon fodder for the opponents of that majority opinion, all right? And like I said, Justice Harlan's dissents provided powerful cannon fodder for the opponents of racial segregation and discrimination, okay? Dissents are not always a good thing, though. In certain cases where rights have been advanced, you know, you will often have justices that were against the expansion of those rights, okay? Justice Antonin Scalia was a famous dissenter. Former Justice Scalia, of course, was a very famous dissenter as well in many cases while a member of the Rehnquist and Roberts Court, all right? And when he felt that the Supreme Court had overstepped its boundaries, such as in Lawrence versus Texas in 2003, as well as Oberfeld versus Hodges in 2015, you know, he wrote very, very powerful dissents, chastising the majority as, you know, effectively mandating public policy upon the whole country. 5 elected lawyers imposing their view upon the whole country, circumventing the democratic process, leaving the people without recourse. All right? Justice Scalia often got personal with his dissents, often naming colleagues in the dissents themselves. Not everyone appreciated that, needless to say. So, that's a dissenting opinion. All right? That takes us next to a concurring opinion. As the name implies, concurring opinions are written by justices, okay, on an appellate court who agree with the outcome of a case, all right? However, they don't often fully agree with the rationale used by the majority to reach that outcome. They agree with the destination that was reached, yes, in siding with petitioner or respondent, but they don't often agree with the road the majority took to get there, all right? That's one reason a justice may write a concurrence. Second reason a justice may write a concurrence is that they may wish to emphasize a particular aspect of the case that the majority may have neglected, okay? A great example of the first one, whereby a justice did not necessarily agree with the legal rationale, but agreed with the outcome, was Justice O'Connor's concurrence in Lawrence versus Texas in 2003. The majority opinion in that case, written by Justice Anthony Kennedy, utilized the 14th Amendment's due process clause to, protect the right of same-sex couples in their intimate, practices without interference from the state, all right? He used the 14th Amendment's due process clause. Justice O'Connor wrote a powerful concurrence in that case where she would have invalidated the Texas law prohibiting same-sex anal intercourse under the Equal Protection Clause, as that law targeted the practice only for male-male sexual intercourse and not male-female sexual intercourse in groups who are similarly situated, providing the perfect grounds to strike it under the Equal Protection Clause, okay? So she would have used that. And though she didn't fully go along with Kennedy's rationale, her concurrence provided a strong, support for his majority opinion. An example of the second, reason a justice writes a concurrence was, to emphasize a point the majority might have left out, was in Justice Potter Stewart's concurrence in Loving versus Virginia in 1967. He fully agreed with Chief Justice Warren's majority opinion in that case, but Justice Stewart wanted to emphasize a point that, a law cannot stand in our system under the 14th Amendment, whereby the criminality of an act is contingent upon the color of the actor. And he's exactly correct. The 14th Amendment's Equal Protection Clause would not allow such a law to stand. All right, and that was exactly what you saw in Loving versus Virginia. All right, the landmark case that struck down Virginia's anti-miscegenation law and thus invalidated them in the remaining states that still had them in the country as of 1967. All right, so that's concurrence. All right, and with both, before I move on any further, with both concurrences and dissents, you will often see justices of the Supreme Court and likely other, state Supreme Courts, for example. You may or may not see them as well file what's known as concurrences and dissents on denials of certiorari. In other words, let's say the Supreme Court, when the Supreme Court denies certiorari in a particular case, all right, one or more justices may dissent from the denial of certiorari to, of course, certify or accept the case for review, all right, and, render a particular judgment on it, all right. If the court denies cert, it refuses to even consider the case in any way, shape, or form. And some certain justices may feel some type of way about that and, write dissents to denial of cert, okay. Other times, they may concur with the denial of cert, all right, and agree. They wanted to emphasize that, yeah, I think it was great we denied cert here, or, that we accepted this case and, vacated it and remanded. There may also be dissents attached to that part as well, all right, dissenting to the granting of cert. You can find all of that, with respect to concurrences and dissents to granting and denials of cert on the U.S. Supreme Court's website. Okay? But this is primarily outlining where you'll see concurring and dissenting opinions. All right? So that takes us to the next type of opinion, a procurium opinion. Procurium opinions are indeed a regular appellate court opinion where the court is typically, though not always, acting collectively, all right? And it issues an opinion that does not list the author. Sometimes that's probably a good thing, all right? But concurrences and dissents, okay, with respect to that procurium opinion, do list the author of the respective concurrences and dissents, all right? Some famous Procurium opinions were Bush versus Gore in 2000. We all remember that one, all right? And Buckley versus Vallejo in 1976. Okay, very important campaign finance case, First Amendment case. All right, so that's Procurium opinions, and literally the Latin term Procurium means by the court. Okay, that takes us next to an in chambers opinion. Now, this is definitely related to the Supreme Court. An in chambers opinion, okay, is written by a justice, to dispose of a particular application by a party for interim relief, okay? You may or may not be aware that the Supreme Court justices have oversight over the federal circuits, all right? And things that occur, legal issues, controversies, your emergency requests that occur within that circuit that fall under that, the Supreme Court's jurisdiction, they can apply to that particular circuit justice for immediate relief, okay? And certain examples of that relief may be to stay a judgment, to vacate a stay of judgment, or to issue an injunction from something happening, all right? So the Supreme Court justices do have power to act in their individual capacities, all right? They can certainly, grant a stay of execution and vacate stays of execution, and indeed grant those injunctions, all depending on what the circumstance. For example, Chief Justice Roberts' area of oversight is the District of Columbia, all right, the U.S. Court of Appeals for the District of Columbia, D.C. Circuit, and the Fourth Circuit, all right, which my own Maryland is in. It covers West Virginia, Maryland, Virginia, and North Carolina, all right, that is the Fourth Circuit, and they are under the jurisdiction of our great Chief Justice. So that's in chambers opinions, okay? It takes us now to the dreaded plurality opinion. Ugh, I hate these. Plurality opinions essentially are opinions whereby, issued by an appellate court, of course, where a majority of justices agree with the result. A majority of justices agree to side with either the petitioner or respondent, but a majority does not agree with the rationale and reasons given. All right? Pluralities, like I said, I really hate these. All right? So with a plurality, you get a written opinion that occurs, pluralities are written when no single opinion garners a majority of the court. So that means on the Supreme Court, if a plurality opinion comes into being, it does not receive the assent of at least 5 members under normal circumstances. All right. So thus, usually pluralities, attract no more than about 3 or 4 justices all agreeing on the same solid reasoning. Okay. In spite of, no opinion receiving a majority of assent from the justices, means at least 5, remember, okay? The plurality opinion got more support than any of the rest of the opinions that were written for all the people that are, siding with the ultimate victor in the case, either the petitioner or respondent, all right? Am I making sense? Hopefully I am, okay? If I'm not, let me just go back a couple of steps and say, the plurality opinion is an opinion that while a majority of the court has agreed to side with either the petitioner or respondent, you can't get at least 5 of them to all specifically agree on the same legal rationale for doing so, okay? And so the plurality opinion, which, is just like any other opinion here, but it got more support than any of the other opinions written by those in the majority, okay? And the plurality opinion typically will only get the support of about 3 or 4 members, all right? So that's not a majority. So what do? Well, that means you've got some questions as to what's the guiding force here, all right? You're not including the dissenters. Remember, they're on the other side. Your plurality is your shaky majority that can't all come together to form a cohesive unit on a single issue of law. All right. So the Supreme Court, in the case of Marks versus U.S. in 1977, gave guidance on how to interpret and apply plurality opinions from the Supreme Court itself. The court held that, pluralities are to be interpreted by the position taken by those justices who concurred in the judgments on the narrowest grounds. And what that means, quite simply, is when you're reading a plurality opinion, you've got to decipher and weed out, the rationale common to all of the concurrences that arrive at the same result. I'll say that again. You looking at the concurrences, aside from the plurality opinion itself, you got to find the rationale that's common to all the other concurrences written, that arrived at the same result. So whatever the common denominator is in all the concurrences, that is the controlling view that, commands how the plurality is to be interpreted. All right. That's the one thing that everybody seems to agree on. Okay. That is how you interpret pluralities. Now you see why I hate them. All right. So that takes us next to a slip opinion. You might see this term if you're doing your legal research. You might be on the Supreme Court website, so forth and so on. You might be on your state Supreme Court website. But in any case, with respect to the Supreme Court, a slip opinion is essentially the first version of a U.S. Supreme Court opinion. It contains the majority, concurrences, and the dissents, and the prefatory syllabus. All right. And this gives you an idea of where we're going, where the court is going with its opinion. All right. Ultimately, the final opinion is what will be published in the U.S. reports of decisions. All right. The court's official publication. All right. And last but not least, we get to a concurrence/dissent. You might see this. You're not going to hopefully see this very often, but you'll often see in a case that says concurrence/dissent. This is known as a special concurrence. Now, this is done by a justice, one or more justices, who agree with the disposition of the case, but not necessarily the opinion and rationale used at all. A great example where you saw a lot of this was the landmark Backy Case, Regents of the University of California against Backy in 1978, where you had half the court siding with Backy, and you had the other half siding with the Regents of the University of California. It was the court's first long-term affirmative action case, the Backy Case. And, 4 justices who agreed with the University of California, the affirmative action program, disagreed on admitting Backy to the school. So that's why they concurred and dissented. The other 4 agreed and with the admission of Backy being ordered admitted to the school, but disagreed with the upholding of the UC Davis affirmative action program. So, each of these, and you're probably wondering, well, what about that 9th justice? Well, right in the smack dab in the middle was Justice Lewis Powell, who was King Solomon here, and split the baby down the middle. He provided, essentially siding with both positions. Powell authored the majority opinion, which ordered the admission of Backy to the school, and also sustained the California UC Davis affirmative action program. All right, so he was the crucial vote here who gave both sides what they want while, allowing something that they didn't want as well. All right, so this is where you saw lots of concurrence dissents. You're not going to see this too often. Most people, much more inclined to just either fully concur or just dissent. All right, so I want to add something else, before I conclude. with respect to Supreme Court opinions, all right, and state Supreme Court opinions, U.S. Supreme Court opinions and state Supreme Court opinions, appellate judicial opinions. For the Supreme Court of the United States, when they meet in conference to, vote on a case and the decision is split, let's say a 5-4, right? If the Chief Justice is in the majority, then he will make the opinion assignment, aka decide who writes the opinion of the court in that case. If the Chief Justice is in the minority, the dissenting side, okay, then the most senior justice in the majority will make the opinion assignment, who authors the opinion of the court in that case, all right? If the Chief Justice, assumingly, is in the minority on the dissenting side, he will make the assignment of dissent. He will decide who writes the dissent, all right? So whenever the Chief Justice is in the majority, he decides who writes the opinion of the court in a given case. He can assign it to anybody he wants to, or he can assign it to himself. When he's in the minority, he doesn't have this power. That power automatically transfers to whoever is the most senior justice in the majority. All right? And with the current court, that's close to roughly being either Justice Clarence Thomas or Justice Stephen Breyer, although Justice Thomas is not likely often at odds with Chief Justice Roberts on most issues, but if they are at odds with each other, and the Chief Justice is in the minority, then Justice Thomas will, of course, make the opinion assignment, all right? And if not Justice Thomas, then in all likelihood it will be Justice Breyer, all right? Because it's more likely to have Chief Justice Roberts and Justice Thomas on the same side than Justice Breyer on the same side of either one of them. But it does happen from time to time. And if Breyer is in the majority and Roberts and Thomas are in the minority, Breyer, being the third in line of seniority, will make the opinion assignment. All right? So that's how that works. And that's typically how it works in state Supreme Courts as well. Okay? When the Chief Justice is not in the majority, then the opinion assignment falls to the most senior member of the court who is in the majority. All right? So, and you can, of course, find substantial amount of information with respect to Supreme Court opinions on the U.S. Supreme Court's website, all right? And remember that all U.S. Supreme Court decisions that are ultimately published are in the U.S. Reports of Decisions, the court's official publication, okay? So when you're out there doing your legal research, ladies and gentlemen, and you might need help understanding what this terminology means, videos like this will certainly help you through. All right. I love doing legal research. I love reading Supreme Court opinions. All right. As you can tell, I'm a huge nerd and I do this stuff for fun and I do this stuff to help you. So that concludes our video on appellate court opinions. All right. Types of appellate court opinions. And, hopefully you learned a thing or two from this. And if you did, I would humbly ask you to drop me a like on the video. And if you've not subscribed to my channel, I invite you to do so now. Your support means more than you will ever know. All right. So I thank you so much for listening. All right. Hopefully I've helped you in your process of doing legal research and understanding appellate judicial opinions and the types that you will encounter. All right. So again, thanks for listening. Take care. Stay safe out there. And I will talk to you at the next video. Peace.